Be me. 46, family court judge in Franklin County, Columbus, Ohio. Making $142,000 plus, full judicial benefits. Been on bench for 8 years. This is my dream job. Worked my entire legal career to get here. Started as family law attorney, 12 years representing women in divorces. Built reputation as fierce advocate for mothers and children. Appointed to judgeship by governor after extensive vetting process. Youngest woman ever appointed to family court in Franklin County. Handle custody disputes, divorce proceedings, child support cases. About 200 cases per year, each one affecting families' lives. Take this responsibility seriously, very seriously. Come from background that shapes my judicial philosophy. Raised by single mother after my father left when I was 8. Watch my mom struggle to raise 3 kids alone. Work 2 jobs, barely make rent, while dad paid minimal child support. He had visitation rights, but rarely showed up. When he did show up, it was disruptive and painful. Get us excited, then disappoint us. Cycle repeated for years. That experience shaped my view of fathers in family court. Most men don't step up. They're unreliable at best. Women are the ones who do the real work of parenting. Carrying babies, raising children, sacrificing careers. Men swoop in wanting custody when it's convenient, or when they want to avoid paying child support. I've seen this pattern hundreds of times as an attorney. Now as a judge, I have power to protect children from it. My courtroom has reputation among family law attorneys. Everyone knows Judge Morrison favors mothers in custody disputes. Not explicitly, but in practice, mothers almost always get primary custody. Fathers get standard visitation every other weekend, some holidays. Unless there's documented abuse or addiction, that's the default. Some people criticize this, say I'm biased against fathers. But I'm protecting children, giving them stability. Keeping them with the parent who's actually been parenting. Not the one who suddenly wants to play dad when marriage ends. This Tuesday morning, typical custody hearing on my docket. Case is Anderson versus Anderson. Contested custody dispute. Mother is Jennifer Anderson, 34, works as nurse at Ohio State Medical Center. Father is Michael Anderson, 36, works as high school history teacher. They have 2 kids, daughter Emma age 8, son Lucas age 5. Married 10 years, filing for divorce, fighting over custody arrangement. I've reviewed the case file, read both attorneys' briefs. Jennifer is asking for primary physical custody, standard request. Michael is asking for 50-50 shared parenting, equal time with both parents. This is red flag immediately. Father's asking for equal custody. Usually means they're trying to reduce child support obligations. Or they're trying to maintain control over their ex-wife. Rarely is it actually about the children's best interests. Hearing begins. Jennifer's attorney presents her case first. Attorney is woman named Sarah Chun. I know her well, good lawyer. Your Honor, Mrs. Anderson has been the primary caregiver throughout the marriage. She manages doctor appointments, school activities, daily routines. She's requesting primary custody with standard visitation from Mr. Anderson. Sarah presents evidence of Jennifer's parenting involvement. Medical records showing Jennifer took kids to all appointments. School records showing Jennifer as primary contact. Statements from teachers about Jennifer's involvement. All standard evidence in custody cases, mothers are usually more involved. Then Michael's attorney presents his case. Attorney is a man named Robert Hayes, older guy, very experienced. Your Honor, Mr. Anderson is equally involved parent. He coaches his daughter's soccer team, helps with homework every night. He's requesting shared parenting plan with equal time. Robert presents evidence of Michael's parenting involvement. Photos of him at kids' events, coaching soccer, attending school functions. Letters from other parents about his involvement. Statement from school counselor about his engagement. Kids' own drawings and cards for Father's Day. He's prepared, I'll give him that, but this doesn't change the analysis. Fathers can be involved during marriage and still not be primary caregivers. Being a coach or helping with homework isn't the same as actual parenting. The mental load, the planning, the management, that's usually the mother. I asked some questions to both parties directly. Mrs. Anderson, can you describe your typical daily routine with the children? Jennifer describes getting kids ready for school, packing lunches, taking them to activities, managing bedtime routines, scheduling appointments, buying clothes, planning meals. The invisible labor of parenting that fathers often don't see. Mr. Anderson, what's your involvement in the children's daily care? Michael describes helping with breakfast, doing drop-offs some mornings, coaching Emma's soccer team on weekends, helping Lucas with reading every night before bed, playing with them in evenings, putting them to bed. It sounds involved, but it's not the same as what Jennifer describes. He's helping, she's managing, there's a difference. Critical moment comes when I ask about decision-making. Mrs. Anderson, who typically makes decisions about children's health care, education. I do, Your Honor. I schedule all the doctor appointments. I communicate with teachers. I make decisions about activities. Turn to Michael. Same question. Mr. Anderson, are you involved in these decisions? Yes, Your Honor. Jennifer and I discuss everything. We make decisions together about the kids. Jennifer's attorney objects to this characterization. Your Honor, if I may, Mrs. Anderson does the research and planning. Mr. Anderson agrees or disagrees, but she does the work. This is common pattern. Fathers claim equal decision-making, but mothers do all the actual work of gathering information and planning. Fathers just say yes or no to options presented to them. That's not equal parenting. That's delegating to your co-parent. Michael's attorney presents argument for shared parenting. Your Honor, research shows children benefit from equal time with both parents. Mr. Anderson is fully capable of providing stable home environment. He has flexible teaching schedule that accommodates children's needs. Shared parenting is in the children's best interests. I've heard this argument hundreds of times. Fathers' rights advocates push this shared parenting agenda. Claim it's about children's welfare. Really, it's about men's rights. About not wanting to pay child support or admit they weren't equal parents. Jennifer's attorney argues against shared parenting. Your Honor, while Mr. Anderson is a loving father, children need stability. They need consistency of one primary home, not shuttling between houses. Mrs. Anderson has been their primary caregiver. That should continue. This resonates with me. Children need stability. Constantly moving between houses is disruptive. Better to have one primary home where they feel settled. Visitation with father on weekends is appropriate. I'll look at the evidence again. Both sides have presented their cases. Technically, Michael is involved father. No question about that. No evidence of abuse, addiction, neglect, any disqualifying factors. In fact, evidence shows he's quite engaged in kids' lives. But that doesn't mean shared parenting is appropriate. Jennifer has been the primary caregiver. That's clear from the evidence. She manages the household, coordinates everything, does the planning. Michael helps, but helping isn't the same as managing. More importantly, I have concerns about his motivation. Why is he pushing so hard for 50-50 custody? Most fathers are content with standard visitation. When they push for more, there's usually an agenda, either reducing child support or maintaining control. I make my decision from the bench, as I often do. After reviewing all evidence and testimony, this court finds that Mrs. Anderson has been the primary caregiver. Children will benefit from stability of one primary residence. Mrs. Anderson is awarded primary physical custody. Mr. Anderson will have parenting time every other weekend, Friday evening through Sunday evening, plus one evening per week for dinner, and alternating holidays as specified in standard parenting plan. Michael's face falls. He looks devastated. He tries to speak. His attorney puts hand on his arm. Jennifer looks relieved, vindicated. Her attorney is satisfied. I continue with the order. Mr. Anderson will pay child support according to Ohio guidelines, based on his income and parenting time allocation. This arrangement serves the best interests of the children. Case closed. Next case on the docket. Don't think about it much after, it was standard custody ruling. Slight modification from typical because Michael was more involved, but still appropriate to give primary custody to mother. 3 weeks later, I start getting calls from Ohio Judicial Conduct Board. Someone filed formal complaint about the Anderson custody case. Complaint alleges I demonstrated gender bias in my ruling, that I ignored evidence of father's involvement and capability. Ruled based on gender stereotypes rather than children's best interests. I'm not worried initially. Complaints happen, rarely go anywhere. Judicial Conduct Board reviews them, usually dismisses them. Judges have broad discretion in custody cases, hard to prove bias. But this complaint doesn't get dismissed, it gets assigned for investigation. Investigator is attorney named David Preston, very thorough. He requests all my case files from past 3 years. Wants to see pattern of my custody rulings. Also requests transcript from Anderson hearing and all communications related to the case. Month later, David calls me for interview about the complaint. Judge Morrison, I need to discuss some findings from the investigation. Of course, I'm happy to cooperate. I've reviewed 87 contested custody cases you've ruled on in past 3 years. In 84 of those cases, you awarded primary custody to the mother. In the 3 cases where father received primary custody, there was documented evidence of mother's drug addiction or abuse. He pauses, waiting for my response. Mothers are typically the primary caregivers, so primary custody makes sense. But in many of these cases, fathers presented evidence of equal involvement, similar to what Mr. Anderson presented. Yet you consistently ruled in favor of mothers regardless. Start to feel defensive. Each case is decided on its individual merits, but the pattern suggests a predisposition toward maternal custody, regardless of father's demonstrated involvement and capability. David continues with more specific findings. In Anderson case, both parents had clean records, both employed in stable jobs with flexible schedules. Both presented evidence of active parenting involvement. Yet you awarded primary custody to mother and limited father to visitation, when father requested shared parenting. He shows me transcript of my questioning during the hearing. You asked Mrs. Anderson to describe her parenting involvement. She listed tasks, scheduling, planning, managing. You asked Mr. Anderson about his involvement. He listed similar involvement, coaching, homework, bedtime routines. But you characterized his involvement as helping, not parenting. Reading it now, outside the hearing, I can see the framing. I did treat his involvement as secondary to hers, even though the evidence showed equal engagement. Judge Morrison, did you consider shared parenting in this case? I considered it and determined it wasn't in children's best interests. What was the basis for that determination? Children need stability of one primary home, but many children thrive in shared parenting arrangements. What evidence specific to these children led you to reject it? I don't have a good answer to that. Just defaulted to my standard reasoning about stability. Didn't actually analyze whether these specific kids needed that. David shows me more evidence from the investigation. I interviewed several family law attorneys who practice in your courtroom. Multiple attorneys stated they advise father clients not to request shared parenting in your courtroom because you never grant it regardless of circumstances. This is damaging. Reputation among bar is significant. I've granted shared parenting when appropriate. In the past 3 years, you've granted it exactly twice. Out of 87 contested custody cases, both times were cases where mother requested shared arrangement. You've never granted it when father was the one requesting. The pattern is undeniable when laid out like this. David presents more findings. I also reviewed your statements during hearings. You frequently ask mothers about their sacrifice and dedication. You frequently ask fathers about their work schedules and availability. The line of questioning suggests different standards for each parent. He shows me specific examples from transcripts. asking mothers about emotional labor and mental load, asking fathers about whether they can handle logistics, treating mothers as natural parents and fathers as helpers, even when evidence showed equal involvement. Judge Morrison, do you believe fathers are equally capable parents? Of course, when they're actually involved. But your rulings suggest you don't believe they can be primary caregivers. That's not true. I just prioritize children's need for maternal bond. Do you have evidence that these specific children needed that? Or is that an assumption based on gender? Can't answer that honestly without admitting bias. Investigation concludes with formal finding. Evidence demonstrates pattern of gender bias in custody determinations. Judge Morrison consistently favors maternal custody, regardless of evidence of paternal involvement and capability. This violates judicial ethics requiring impartial decision-making, and Ohio law requiring custody decisions based on best interests of child, not gender-based presumptions. Judicial conduct board schedules formal hearing on the findings. This is serious. Could result in public reprimand or worse. I hire attorney to represent me, woman named Patricia Williams. She's experienced in judicial ethics, knows how to defend these cases. We prepare for the hearing, reviewing all the evidence. Patricia is honest with me in private. The pattern is really bad, 84 out of 87 cases to mothers. That's statistically significant evidence of bias. But mothers are usually the primary caregivers. Not in all 87 cases. I've reviewed the files. Many fathers presented strong evidence of equal parenting. You still ruled for mothers almost automatically. She shows me specific cases that are most problematic. Johnson case. Father had been stay-at-home parent for 3 years. I still gave primary custody to mother because she was reestablishing career. Martinez case. Father had flexible work-from-home job. Mother worked 60-hour weeks. I still gave her primary custody. Thompson case. Both parents equally involved. Father had better housing. I gave primary custody to mother despite father's superior resources. In each case, I found reasons to favor the mother, even when objective evidence suggested father was equally or more suitable. Patricia asks the difficult question. Why do you think you ruled this way consistently? I was protecting the children. From what? These fathers weren't abusive or negligent. From disruption, from losing their primary caregiver. She's quiet for a moment. Or were you protecting them from what happened to you as a child? That hits hard. Hadn't thought about it that explicitly. My father abandoned us. I don't want other kids to experience that. But these fathers weren't abandoning their children. They were fighting for more time with them. That's the opposite of abandonment. She's right. I've been projecting my childhood experience onto every father who came through my courtroom, assuming they'd all be like my father. Unreliable, disappointing, not really committed to parenting. Hearing before Judicial Conduct Board is brutal. 3 board members, all experienced attorneys and judges. They've reviewed all the evidence David compiled. The statistical pattern, the specific cases, the attorney testimonies. Chair of the board is retired judge, woman named Margaret Foster. Judge Morrison, you've had distinguished career in family law, but this evidence shows a troubling pattern of bias. Can you explain the disparate outcomes in your custody rulings? Patricia has prepared me to acknowledge rather than defend. I recognize that my rulings have shown a pattern. I believed I was acting in children's best interests, but I understand now that I may have applied gender-based assumptions. Margaret presses further. May have. The evidence is quite clear. 84 out of 87 cases awarded to mothers, even in cases where fathers were demonstrably equal or superior parents. That's not may have, that's systematic bias. Another board member, a man named Thomas Wright, speaks up. Let's discuss the Anderson case, specifically since that triggered the complaint. Father presented substantial evidence of involvement. Coaching, homework help, active participation in children's lives. No evidence of unfitness, abuse, or neglect. Why did you deny his request for shared parenting? I answer as honestly as I can. I believe children needed stability of one primary home. Did you have evidence specific to these children supporting that belief? Or was it a general assumption? Have to admit it. It was a general belief I applied to most cases. Thomas continues, did you consider that denying father equal time, based on general belief rather than specific evidence, might actually harm these children's relationship with their father? Never thought about it that way. Always assumed limiting father's time protected children. What if it actually harmed them by limiting important relationship? Third board member asks about my background. Judge Morrison, we understand you were raised by single mother. After your father left the family, do you think that experience influenced your custody decisions? Patricia has advised me to be honest about this. Yes, I believe it did influence me. I saw my mother struggle and wanted to protect other mothers. But I recognize now that I was projecting my experience onto situations that were very different. Margaret asks the critical question, do you believe you can be impartial in future custody cases? Given this acknowledged bias and personal history, this is the moment that determines everything. If I say yes, they might give me another chance with oversight. If I say no, I'm admitting I can't do my job. Patricia and I discussed this. Honesty is the only option. I believe with training and self-awareness, I could improve. But I recognize the pattern is deeply ingrained. It might be difficult to completely overcome. Board goes into closed session to deliberate. Patricia and I wait outside for 2 hours. She tries to prepare me for possible outcomes. Best case, public reprimand and mandatory training. Worst case, they recommend suspension or removal from bench. Board calls us back in. Margaret delivers the findings. The board finds clear and convincing evidence of gender bias in Judge Morrison's custody determinations. This bias violated judicial ethics canons requiring impartiality and violated Ohio law requiring best interest analysis rather than gender-based presumptions. She continues with the consequences. The board is recommending to the Supreme Court of Ohio that Judge Morrison be removed from the bench, effective immediately. Feel like the floor dropped out from under me. Additionally, we are recommending suspension of her law license for a period of 2 years, after which she may petition for reinstatement. Not just losing the judgeship, losing my license to practice law. My entire career, everything I work for gone. Patricia tries to argue. This seems excessive for bias that was not intentional. The bias may not have been intentional, but it was systematic and harmful. Judge Morrison's rulings affected 87 families over 3 years. Fathers were denied equal parenting time based on gender. Children were denied full relationships with their fathers. This isn't a single error in judgment. It's a pattern of discrimination. Thomas adds, we take seriously our responsibility to protect children and to ensure fair treatment in Ohio courts. Judge Morrison's bias undermined both of those principles. Decision goes to Ohio Supreme Court for final approval. They uphold the board's recommendation unanimously. I'm removed from the bench immediately. Law license is suspended for 2 years pending review. The news coverage is extensive, humiliating. Columbus judge removed for gender bias in custody cases. Family court judge lost license after favoring mothers. Articles detail the statistical evidence, the specific cases. Interview attorneys who practiced in my courtroom. Many say they're not surprised. The bias was well known. Some fathers from my cases speak to media. Men who were denied equal parenting time with their kids, who paid child support for years while getting limited visitation, who felt discriminated against but had no recourse. Michael Anderson gives interview about his case. I love my kids and I'm a good father, but Judge Morrison treated me like I was incapable. Just because I'm a man, she never even considered that shared parenting might be best. He's right, I never really considered it. Just defaulted to maternal custody because that's what I believed. His kids are now in shared parenting arrangement. After his attorney appealed my ruling to different judge, new judge reviewed evidence and granted 50-50 custody. Kids are apparently doing well with the arrangement, thriving with equal time with both parents. Everything I said wouldn't work is working fine. 6 months after losing my judgeship, I'm 47, unemployed. Can't practice law for 2 years while license is suspended. Have to find non-legal work to pay bills. End up taking job as paralegal at small firm. $45,000 salary, less than a third of what I made as judge. From presiding over courtroom to filing documents. From making decisions that affect families to scheduling depositions. Complete professional collapse in 6 months. Spent a lot of time thinking about the 87 cases. All those fathers I limited to every other weekend visitation. Because I assumed mothers were more important parents. All those children who got less time with their dads. Because of my biases and projections. Think about Michael Anderson specifically. He was a good father, involved, capable, loving. And I gave his kids to their mother primarily. Because I couldn't see past my own childhood experience. Couldn't imagine that fathers could be equal parents. That kids could thrive with shared parenting. That my assumptions about gender were wrong. 1 year after removal, some of my cases are being appealed. Fathers are filing motions to modify custody based on judicial bias, arguing that my biased rulings should be reconsidered. Several are successful. Judges grant new hearings. Shared parenting arrangements are being implemented. Kids are adjusting fine, sometimes better than before. Fathers are getting equal time they should have had all along. Each one is evidence that I was wrong. That my rulings hurt families rather than help them. 2 years later, I'm 49, eligible to petition for license reinstatement. Have to appear before Bar Association and demonstrate rehabilitation. Have to show I understand what I did wrong and won't repeat it. Patricia helps me prepare for the hearing. You need to show genuine understanding of the harm you caused. Not just acknowledgement that you had bias, but real comprehension of how it affected families. Hearing before Bar Association committee is intense. They ask about specific cases, my decision-making process, why I consistently favored mothers regardless of evidence. I was operating from deeply held belief that mothers are primary parents, based on my own childhood experience and socialization. I applied that belief uniformly without truly analyzing each case individually. Committee member asks tough question. Do you understand the harm this caused to fathers and children? Yes, fathers were denied equal parenting relationships. Children lost time with loving, capable parents because I couldn't see past my own assumptions about gender roles. Another member asks about specific cases. In the Johnson case, father had been stay-at-home parent, yet you gave primary custody to mother who was working full-time. What was your reasoning? Have to admit the truth. I believed mothers were naturally better primary caregivers. Even when evidence showed father was actually the primary caregiver. That was gender bias, pure and simple. After 2-hour hearing, committee votes on reinstatement. They grant conditional reinstatement of my law license. But I can never serve as judge again in Ohio. Can practice family law only under supervision for first year. And must complete extensive ethics training. Get job at family law firm, but as junior associate. Despite 20-plus years of experience, I'm supervised by younger attorneys, making $78,000, half of my judicial salary, handling uncontested divorces and simple custody modifications. Nothing complex, nothing involving judicial discretion, because nobody trusts my judgment after what happened. 3 years after removal, I'm 50, still rebuilding. Practice law in limited capacity, reputation permanently damaged. Known in Columbus legal community as the biased judge. The one who got removed for discriminating against fathers. Run into Michael Anderson at courthouse one day. He's there for something related to his kid's school. We make eye contact, it's awkward. Haven't seen him since the hearing. He approaches me, surprisingly kind expression. Judge Morrison, how are you? I'm doing okay, practicing law again in limited capacity. That's good. Awkward silence. Then I say what I should have said years ago. I'm sorry for how I ruled in your case. You were a good father, and I didn't give you fair consideration. He's quiet for a moment. I appreciate you saying that. How are your kids? Are they doing well with the shared arrangement? They're great, really thriving. Having equal time with both of us has been good for them. Every word is confirmation that I was wrong. I'm glad to hear that. I was wrong about shared parenting, about a lot of things. Michael nods. I know you thought you were protecting kids, but you were protecting them from something that wasn't there. My kids needed their dad just as much as their mom. You couldn't see that because of your own experience. He's more insightful than I gave him credit for. You're right, I was projecting my childhood. My father was unreliable, and I assumed all fathers were. But you weren't like my father. You were fighting for more time with your kids, not less. Michael is gracious. I hope you've learned from it. I hope other judges learn from it too. Kids need both parents when both are fit and loving. Gender shouldn't be the determining factor. We part ways, him heading to successful life with his kids. Me heading to courthouse to file routine motions. 4 years after removal. See article about family court reforms in Ohio. New guidelines require gender-neutral custody decisions. Shared parenting presumed unless evidence shows otherwise. Article mentions my case as catalyst for the reforms. After high-profile removal of biased judge, Ohio has implemented stricter oversight of custody determinations. Judges now required to document specific findings. Can't just default to maternal custody based on gender. Must consider shared parenting unless evidence contradicts it. My bias and removal led to system-wide changes. That will benefit countless fathers and children. But on the cautionary tale, the example of what not to do. The judge who let personal experience override professional judgment. Who hurt families while believing she was helping them. Now I'm here, 51, practicing family law as supervised associate. Making $82,000, a fraction of my judicial salary. Handling simple cases, never trusted with complex custody disputes. While other judges implement the reforms my failures necessitated. While fathers get fair hearings I never gave them. While children benefit from shared parenting I never allowed. All because I projected my childhood trauma onto every case. Assumed all fathers were like mine, unreliable and uncommitted. When actually many were like Michael, loving and devoted. Fighting for relationships with their children. I denied them based on gender bias I couldn't see. That's what cost me everything I worked for. My judgeship, my reputation, my career advancement, my ability to make meaningful difference in family law. All lost because I confused protection with discrimination. Couldn't separate my personal experience from professional judgment. Treated fathers as inherently less capable parents. Just because they were men. That's my legacy in Ohio family law now. The biased judge who got removed and lost her license. The cautionary tale in judicial ethics courses. The reason new oversight procedures exist. Still believe in protecting children. Still care about family welfare. But learn too late that protection means impartiality. Not gender-based assumptions about who's better parent. Not projecting personal trauma onto other families. Not denying fathers equal consideration because mine was absent. That's the expensive lesson I learned after losing everything. After 87 families were affected by my bias. After my career was destroyed by my inability to be fair. After children lost time with fathers because I couldn't see past my assumptions. Now working as junior associate at 51. While judges I once supervised make decisions I'm not trusted to make. While the fathers I discriminated against raise their children equally, proving every day that I was wrong about everything. That's what I live with, what I can't undo. The harm I caused thinking I was helping. The bias I enforced thinking it was justice. The families I damaged thinking I was protecting children. All because I couldn't see that good fathers exist. That kids need both parents equally. That gender shouldn't determine custody. And by the time I learned that truth, it cost me my career, my license, my legacy. Everything I built over 20 years in family law. Gone because I confused feminism with fairness. Protection with prejudice. Justice with gender bias. That's my story, my failure, my consequence. Living with it every day as supervised associate, while the system I damaged recovers without me.